Happy days appear to be briefly afoot in Melvindale, Michigan, because, as I'm sure most of you have heard now, Michigan's worst police officer, Lieutenant Matthew Furman, has been officially charged with several felonies arising out of the three incidents that made him YouTube famous, either from the Civil Rights Lawyers channel or my channel or the local news or everybody who's been talking about this guy. But we're going to bring you the arraignment video and talk about what's next for Lieutenant Matthew Furman. Let's talk about it. What's up, you guys? Welcome back to Southern Draw Law. My name is James White, criminal defense attorney, former prosecutor, former police officer. Now, if you don't remember Matthew Furman, I've done two videos on him, one on the original reason why everybody was talking about him, and that sort of briefly touched all of the cases he was involved in that are the source of the problems here. Or the civil rights lawyer did a similar video on him from his previous cases, from grabbing a guy by the hair and tasering him multiple times, tasering a lady multiple times, and stomping a guy after a pursuit multiple times. So those incidents have all come back to bite him and have culminated in felony charges from the Wayne County prosecutor.
We begin tonight with a Melvindale police lieutenant hit with a slew of criminal charges that could send him to prison for years. Welcome to 7 News Detroit at 6. I'm Carolyn Clifford.
And I'm Mike Duffy. Thank you for joining us. Now, the charges stem from 3 separate alleged assaults that were all revealed by the 7 investigators.
For the last 8 months, 7 investigator Ross Jones has shed light on Lieutenant Matthew Furman's polarizing history with the department.
From a string of lawsuits to allegations of excessive force and claims that he improperly tased people.
And while Ferman has withstood past efforts to take his badge, the charges announced today mark the biggest threat to his law enforcement career.
7 investigator Ross Jones has the latest on these major developments.
When they talk about being tough on crime, sometimes that means being tough on criminals.
Today, Lieutenant Matthew Furman is accused of being a criminal after Wayne County's prosecutor authorized charges stemming from 3 separate alleged assaults dating back the last 4 years.
When you tell the cops, can you tell?
Stand hands on the roof! Stop or you will get tasered! When I tell you to do something, you do it! End of story!
2 of the incidents involve use of a taser. In July of last year, Furman stopped Dracar Williams for driving around traffic barricades. Williams, who had a suspended license, should not have been driving. And after he refused to provide his name, Furman moved to arrest him. While his partner held Williams outside of the car.
Hands behind your back. Interlace your fingers. Hands behind your back.
He got me!
Furman began to tase him repeatedly.
Stop! Stop!
Furman said Williams was uncooperative, that he was fearful he could have been carrying a weapon. After Williams was handcuffed, Furman would be seen arguing with him again. After Williams stood up, Furman did this.
You will not get up without our permission.
Man,
Sit the down.
I am sitting down. You pulling my hair.
He was never disciplined by his department, but today prosecutor Kim Worthy charged him with misconduct in office, felonious assault, and assault and battery. We spoke with Williams today.
I told him, you're going to lose your badge over this. No, I'm not. He was confident.
You're going to lose your badge.
I ain't gonna lose. You're gonna lose your freedom because you get to go to jail today, mother.
But it's because of you that they did something. So if it wasn't for you actually looking into something, they wouldn't have never found it.
Morning. Lieutenant Furman, Melvindale Police Department.
He would also be charged over this stop from 3 months earlier when Furman pulled over a vehicle that was already parked. Alicia Cook and her 2 daughters were sitting outside of a school while Cook waited to drop off her 11-year-old at cheerleading practice. When Cook didn't provide her license and registration, Furman tried to pull her from her vehicle, and after she resisted, he took out his taser and fired.
You're gonna be tasered! Head out! Out!
The charges that would be filed against Cook would be dismissed, and today she is suing Furman and the department for how she was treated.
I was terrified from you. You terrified me. You scared me. You scared me.
Furman was not disciplined by the department.
I am grateful that they, taking the time to say, hey, this person's actions was not okay. We're going to do something about this.
Today, we spoke with Alicia Cook.
My daughter that I was taking to school She's in a mental hospital today, you know, so his actions caused a lot of pain, but I do forgive him.
Watch his door.
The earliest charges stem from this 2021 police chase. The suspect had stolen a vehicle, police said, after striking an officer. And after his vehicle crashed, the man fled on foot before officers surrounded him. As officers tried to subdue the man, a Dearborn officer's body cam caught Furman repeatedly stomping on the man's leg. Another can be heard warning that cameras are rolling. The Dearborn officer reported Furman's actions to his supervisor. Furman said the man was resisting, and he used the stomps as a form of pain compliance. He was not disciplined by Melvindale, but was charged by the prosecutor today. Ferman has previously defended his actions, calling himself a proactive police officer and saying it's never been more dangerous to be in law enforcement, as evidenced by the murder of fellow officer Mohammed Saeed just last year.
You know, people say, well, Furman uses too much force, he's too aggressive, he's a robot. And again, my goal is to go home alive.
In his mind, he think he right, but finally somebody else see that he wrong.
Well, Furman has not responded to messages seeking comment, nor has the city's police chief. The mayor declined comment on the charges from today. Lawrence Coogan, the city's corporation counsel, told me by phone he plans to meet with the city's public safety commission and deputy chief soon, moving to suspend Furman without pay as a result of the charges. He said the city needs to investigate who within the department allowed Furman's behavior to continue in the first place. Furman is set to be arraigned tomorrow at 9 a.m.
Now, this morning, there was an arraignment, and that dealt with whether or not he was going to get a bond because he was currently in jail, whether or not he was going to be allowed to possess weapons. So without going too far, we'll just let you watch the arraignment video, and then I'll have a couple comments about some of the things that are said that will give us some insight. Let's check it out.
Morning, calling Matter Matthew Furman. These are our case numbers 25FM. 3760, 3761, 3762. I'm Judge Page. I swore out complaints in these three cases yesterday. I appreciate the attorney's cooperation. We set up an arraignment for this morning. Can I get appearances, please, beginning with the prosecutor?
Good morning, Your Honor. Matthew Makepeace on behalf of the people, P82796.
And good morning, Your Honor. Dennis White, P79560 on behalf of Matthew Furman, who appears by way of Zoom.
Mr. Furman, can you state your name, please?
Yes, Your Honor. Matthew Furman.
Counsel, how do you wish to proceed for arraignment purposes?
Your Honor, I have not received discovery. I just want to confirm with the prosecutor that the charges listed in the district court website would be the charges for the three cases. Is that correct?
That's correct.
Okay, Judge. Well, given that, we waive all arraignments, Daniel.
Okay, so just so you understand, generally when you are charged with something, you can have an option of what's called a formal reading. That's where the judge would formally make you apprised of all of the things that you are accused of. Generally, the common practice between lawyers is to waive a formal reading and just enter a plea of not guilty and then allow the judge to set bond. So a formal reading would look like you are accused of A, B, C, or D, and they would lay out the elements and all that stuff. Most of the time, you know, people know what they're charged with. They waive the formal reading, but they are entitled to a formal reading under the law, and that's the reason that was offered. Let's continue.
All right, let's go right to bond. I'll let the prosecutor go first. Go ahead.
Judge, we would be asking for a personal bond when it's either in this case and and that the defendant would not be allowed to possess any weapons, and if he has any firearms registered to forfeit them to a law enforcement agency.
Counsel for the defense, address bond.
Judge, we would agree with a personal bond, but I think the next two steps are a bit far. First, it's Heather. I think it's completely inappropriate. Mr. Furman is still, Lieutenant Furman is still a police officer in this community. He lives in this community. He's not running from these charges, and we fully intend on going to trial on all three cases and kind of look forward to it. But given that, Judge, he's not going to run from the jurisdiction, nor is he any danger whatsoever. He will not be a police officer, obviously, during the time, and he's unethical anyways after one of his co-workers were murdered. And so given that, he's not running, he's not a danger. So I think Heather's Heather's beyond the stretch.
Okay. So let's stop here for a second. So I'm a little surprised, first of all, that the state didn't at least ask for something higher than a personal bond. A personal bond is where you basically just guarantee through your signature, or personal recognizance bond, a PR bond, sometimes it's called, but it's basically just, you agree that you're going to come to court. They're saying that you're a low flight risk, and importantly, you don't have to post any money to get out of jail. So they could have offered for a property bond or a surety bond, which is where you have a bail bondsman come in and stand in on your behalf. Or they could have asked for like a 10% bond, which is like, if it was a $50,000 bond and it was a 10% bond, he would have had to post $5,000 cash to get out of jail. We could have asked for a cash bond where he has to post the whole $50,000. Generally what happens, it's kind of like a negotiation for a car loan. You start high and you settle somewhere in the middle. So it's interesting to me that the state did not ask for any sort of financial burden to be coming out of pocket for Mr. Furman. And they've sort of started here with a personal bond, meaning that obviously the defense is not going to object. The interesting part of that, a bombshell revelation here, not that much of a surprise considering that the reason that Mr. Furman is basically still employed is because he loves to and knows how to manipulate the system. Lawyer let the cat out of the bag a little bit. He said, and I don't know if you caught that or not, but he's not going to be a police officer probably after this anyway, because he's been off on medical after watching his colleague be murdered. A Melvindale police officer named Mohammed Syed observed, I guess, somebody throw a cigarette on the ground and went over and ordered this person to pick it up. There was a confrontation. Syed was shot and killed by this person that he was trying to order to pick up this cigarette from. I haven't looked at that case. I don't know. But the interesting part of this is that what that means is that Ferman knows that he's getting ready to get fired over this, and he's using a psychological disability to try to seek a pension from the police department. So he's been off for a year. This happened about a year ago when this officer Syed was shot and killed. And so Furman has been off, probably reading the tea leaves, seeing the writing on the wall here. He's going to try to squeeze a medical pension out of this. And that should be the indicator when the lawyer says, well, he's been on medical since he is suffering from the trauma of having watched his colleague killed. Now, there's no doubt that when you see a fellow police officer get killed, that you're going to suffer some sort of trauma from that. I'm not arguing that he didn't suffer some trauma from that. What I am arguing is that any read on Matthew Furman's personality from any person who's ever studied human beings would indicate that he's going to squeeze this for some medical retirement. That's the whole play. That's what it's all about. That's why he's off on medical instead of, because he knew they were coming for him. They were tired of him. And his position is probably like, hey, you want to get rid of me? Fine. It ain't going to be because you fired me. It's going to be because you paid me. So he's already been working for that. That will probably be the end result, is that he will end up getting a retirement pension for a medical retirement as opposed to actually being fired by the Melvindale Police Department, because they've been trying to get rid of him for years and they can't because he's smarter at working the system than they are. Let's continue.
I understand the firearms issue that the people bring up. But again, he's still a police officer. He hasn't committed any problems. Every allegation here is something that happened on the job. He's not run out after work and got drunk and caused problems with firearms or anything of that nature. He still has a Second Amendment right as well. Judge, I just think it's a step too far. These violations that have been charged were looked over after media reports, so then they went through all of his files and came up with 3 things to charge him, which he was no danger 2 or 3 years ago after the incident. Nothing's happened in his personal time. Nothing's happened after the second incident that they now bring up. So I think that's a stretch too far. I believe personal bond is appropriate, of course, in this case. He will show up to court. He's retained an attorney. I came on board prior to the arraignment. So I was immediately advised by the media first that there were charges. That was our first notification. But we're here, we're ready to fight, and we're not going anywhere. So no danger to the community whatsoever. And he's not a flight risk, Judge. He's going to be in court. I think personal bonds is sufficient without a title requirement or the firearm required.
You mentioned he's off on medical. Is he receiving mental health counseling or treatment?
Yes, that is correct. He is after he's the one who on the officer's side. And so he's been off of work for, it's been over a year now. But yeah, he is receiving mental health counseling. Compliant actually is not ordered to do it in condition of employment. He's doing it because he needs it. He wants it.
Okay, so notice that the lawyer realized the implications of that question. So again, this is another tea leaf thing. The judge is asking that because, look, if he's receiving psychological counseling, this is a double-edged sword, right? That makes him subject to maybe some scrutiny as it relates to firearms, in addition to the fact that he's been charged with felonies. Okay, so you're making the argument that this guy's seeking some sort of consideration under the tenets of a medical because of psychological trauma, and you're also going to stand here and argue that he needs access to weapons, right? So that look on the lawyer's face when he had to answer that question candidly is, yeah, right? So of course he's receiving, but we're in complete compliance, all that stuff. So that one kind of bit him in the butt a little bit because, look, he's got felony charges pending. Yes, he is a police officer, but he's making a double-edged argument, which is that, well, he's probably not going to be a police officer anymore, and he's getting mental health counseling. Oh, well, but he's got a Second Amendment right. You got to pick one, guy. It's not going to be both. If he's going to be a completely, psychologically intact police officer, then he might need a gun. But he ain't, because he's seeking a medical retirement for psychological trauma. So now you've acknowledged that he's receiving psychological treatment and he's probably not going to be a police officer anymore. So you can only hold on to that gun argument with so much strength before you have to concede that, you're probably right. Let's continue.
All right, the factors I'm to consider in determining bond are whether he's a flight risk and whether he's a danger to the community. I don't think he's a flight risk. To that extent, I think a personal bond is appropriate. I'm setting a $50,000 personal bond. Whether he's a danger to the community is another issue. I want him to continue his mental health treatment, provide proof of that. I want him to take any medications as prescribed. I agree with the prosecutor that a no weapons condition is appropriate. I've heard the allegations in this case. I've seen the video. I think no weapons are appropriate. We need to have a discussion about, or the two of you can have a discussion about turning over any weapons to the prosecutor. I also heard allegations at the time I swore out the complaint about concerns from at least one of the victims about contact. So I believe a GPS tether with a no contact order is appropriate. I don't know if those allegations are legitimate, but at this point, I don't think a no contact order is a problem, nor do I think a tether should be a problem. I'm also ordering as a bond condition that he get fingerprinted ASAP. I believe it's appropriate moving forward that I disqualify myself per MCR 2.003. Lieutenant Ferman worked in this community for several years. There could be an appearance of impropriety. If this court retains the case, I'm going to sign off a disqualification order today. I expect Judge Corbett, the other judge in this court, will probably do the same. And we'll get dates. We'll get an assignment from the state to another court and hopefully get dates within the 21-day rule. To the extent anything I've said is confusing or you want some final discussion of it, go ahead, Mr. Makepeace, you go first.
That's the only, you mentioned that the defendant must get fingerprinted or live scanned. He will have to do that twice. One with the Michigan State Police and one with my office. Both of those agencies are investigating agencies on that case. I can work out the logistics with that with Mr. Whitey, though.
All right. Mr. Whitey, anything else you want to address?
Judge, we can take care of the firearm issue. I'll get it and show proof that it's in a staple case or turned over during pendency of the case.
All right, I'm going to try and act promptly here, get everything off to the state. We'll get the bond paperwork out, get everything off to the state to get this reassigned, and get you gentlemen some new dates as soon as we can. Anything else?
No, I'm leaving, Judge. Thank you.
I'll be from Mr. Furman. Thank you, Judge.
All right, thank you, gentlemen.
Okay, so a couple of surprises there. It looks like the judge has decided to disqualify himself. That's Michigan Court Rule 2.003. We can pull that up and take a look at it. But basically, it's just for, a judge must disqualify themselves in any proceeding in which their impartiality might reasonably be questioned, including but not limited to situations where bias or prejudice exists, prior involvement with as an attorney or a controversy or as a material witness, financial interest, family relationships, prior judgment where the judge has previously served as a judge in the matter or controversy, or this is the, it looks like the one they're hanging this on is appearance of impropriety based on objective and reasonable perceptions. The judge has a serious risk of actual bias impacting the due process rights of a party or has failed to adhere to the appearance of impropriety standards set forth in Canon 2 of the Michigan Code of Judicial Conduct. Look, the judge is just trying to get out in front of this. Somebody's going to accuse him of bias, either the victim or the defendant. He just wants to be out of the way of it. It's actually a pretty good idea for any judge that's ever heard a case on this, which is why he said that the other judge might do the same. Look, they just want to have their hands off of it. They don't want to be blamed by either side as to what happens with this. So it's a pretty smart play by the judge, to be honest with you, because, hey, ain't no bugs on me, bro. Go do your thing. I don't want any part of it. Didn't have anything to do with me. Stay out of the fray. That's pretty smart, judicially speaking. Let somebody else deal with it. So that's what he's going to do. I was a little surprised that he gave him a GPS tether. I want to know where this cat is all the time. I don't want him out in the public at all. I think he's absolutely a danger to the public, but I only say that because he's been able to get by with every single thing that he's ever done. And there's nothing in his behavior that would indicate to me that there's been any sort of like personal awareness attached to his behavior. In closing, I don't really understand why the prosecutor didn't ask for something out of pocket. I think if you're going to charge the guy with felonies, you make it look like you're actually interested in prosecuting him by kind of going for the throat in the bond. Start at the beginning, go strong as you can if you actually want this guy. It almost seems like they're bringing charges just so that the police department can get some help getting rid of him because they have not been able to get rid of him. So maybe it's public pressure, maybe it's community backlash, not really sure exactly why they've charged him. I mean, they charged him because he committed a bunch of offenses, but why 4 years later? Why now? Why, in conjunction with him trying to seek a medical retirement? It's unclear. I don't have a lot of faith in the purity of the process here. I don't really know exactly why now. I'm glad. I don't think he spends a day in jail. I don't expect that he's going to walk away with a felony conviction, and I only say that because it doesn't seem like the prosecutor is really kind of like going for the throat in the bond. That kind of tells me they don't really care whether he's locked up. So I'm a little surprised by that. I'll follow it, keep you guys up to date on the changes. I'm happy that he's been charged. I suspect you're happy. It'll be interesting to see how this plays out. I don't expect that he's going to be a police officer anymore, at least not in Melvindale. But he's pulled a few tricks out of the bag, a few rabbits out of the hat before, and he always kind of like brushes himself off and ends up looking better on the other side. So it'll be interesting to see how it plays out. But just wanted to bring it to your attention. I've gotten so many emails from my followers, mostly people celebrating the fact that he's been charged. So I just wanted to put it on your radar. Just wanted to report the happy update. I hope he gets convicted, obviously. I hope he goes to prison. I don't think he will. I don't really have any faith in this sort of thing with police officers, especially where there's not some body, there's nobody dead. There's no real, people will get outraged over this and then they'll move on. And so I'm a little surprised to see him charged at all, to be honest with you, but I'm happy it's there. So come and join me over on Substack. I'll probably write a companion blog as the case unfolds. It's absolutely free to join. You can join on a paid tier if you want to, but that's only for people who want to support the channel monetarily. I don't put anything on Substack that you have to actually pay for. If you don't want to join the Substack community, but you'd like to support monetarily, I'll put my Venmo and PayPal links both here on the screen as well as in the description. Please remember to like and subscribe and leave a comment on the video. Check out some of the other videos on the channel and leave a comment on there as well. Until I see you again, take care. Always film your interactions with the police and keep your evidence to yourself.